can you do that?
Yeah, put it in the item.
Can I do that now,
You
Bill?
can.
All right.
When you get it where you want it, hit the stop button for me. And then try and see what it does. All right.
Maybe it's as high as it goes. There you go. A little higher.
That's as high as it goes.
That's as high. That's good for me.
So it makes you put it down first,
Well,
and then it's a glitch.
Sometimes it just clicks. So feel free if you want to lower it when you're up, feel free to do so. If you need help,
Do you want to test that?
just
Joe?
let me know.
So, yeah, based on, I'll probably just, am I allowed to pull them?
Down and then
Okay.
we'll work on it. Yep. All right.
I don't know. Well, I think it's more like, you put in like a question, like a report, and then it's this, does this make policy? Now, does this new jurisdiction, you understand? And then it throws back an answer, like an analysis, and it's, you know, it may not be, there may be errors, right, because, you know, it has to. But then you can ask follow-up questions, it does not exactly wrong, you can answer follow-up questions. The follow-up questions can hold my question. Sometimes my questions are bad questions. And I think, what kind of response can you make? So exactly what you want. How do you question? In certain things, to see if I can get like a better answer out of it. Get an answer. Some of the answers that I actually want answered. So that the question that I ask you the right question to get the answer. It's helpful with that. It's also helpful. When I manage course, these, all of this works. If I like the provisions usually, I make sure that it's overall calculated to this.
All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case scheduled for oral argument this afternoon, the case of Westlake Reinsurance, Inc. versus Florida Department of Financial Services as receiver of guaranteed insurance company. May I approach counsel?
Thank you, Your Honor.
Counsel, here we've allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
I would, Your Honor. I'd like to reserve 5 minutes for rebuttal.
So noted, Madam Clerk. You may proceed.
Good afternoon, Judge Lewis, Judge Thomas, Judge Nordby. My name is Tom Pluffjohn. I am appearing with my colleagues Connis Brown and Samantha Espada, and we're here on behalf of Westlake Reinsurance, who I will refer to as Westlake Re. May it please the Court. The Department of Financial Services, when it was appointed receiver of the guarantee insurance company, marshaled both assets of the estate and non-assets of the estate. Westlake Reinsurance is an owner of a portion of the non-estate assets that were marshaled by the DFS, which are identified in the funds withheld account. Westlake was a reinsurer of GIC, and its relationship was governed by a written contract, the quota share agreement, which the Circuit Court judicially noticed. As part of its actions as receiver, DFS, standing in the shoes of GIC, was responsible for reporting the balance in Westlake's funds withheld account and for informing Westlake of the required minimum balance that had to be maintained in that funds withheld account as security or collateral for debts that Westlake may owe GIC. Westlake, by contract, is entitled to possession of its funds from the funds withheld account when the balance of the funds withheld account exceeds the required minimum balance.
Then, counsel, why couldn't Westlake have filed a breach of contract action in 2018 when the department refused its request for the $5.1 million in GIC's account?
Because it did not have a cause of action at that time. The issue with regard to the ability to enforce the agreement under the quota share agreement required that Westlake, in order to be able to file anything, had to be able to make a credible claim that there were excess funds in the funds withheld account. When the DFS took over receivership, they did not know what the actual funds in the funds withheld account were, and therefore had not provided that information to Westlake. The first time that they ever provided that information to Westlake was in April in 2023. What the DFS had done prior to that date was that they had adjusted the account with the maximum reserve amount you could have with regard to certain insurance claims, which showed that there was no balance or no excess fund balance in the reserve account.
But what about the January 3rd, 2018 letter that was sent to DFS by Chad Pinheiro, who said, you're holding $5 million of our money and we asked that it be remitted? So from the outset, as early as 2018, the position of Westlake was that $5 million, $5 million was being held and it should be remitted.
Judge Norby, that would be the position, but there's a difference between taking a position where one is trying to negotiate a settlement and one having sufficient information that would allow one to bring an action under the contract. And when we were in negotiation with DFS, and DFS actually indicated we don't have all the information yet, and we were in a holding pattern as a defendant. In April 2023, because they had satisfied so many claims, they were able to reduce the reserves that were actually appeared on the funds withheld account. By reducing the reserves to reflect actual claim payments, what ended up happening is they revealed that when, even assuming the worst case scenario for reserves, there was $1.967 million that was available as an excess fund. Pursuant to the quota share agreement, which is Section 7, and it was paragraphs C, D, E, F, and G, within 30 days, Westlake Re had to make a claim for return of possession of those excess funds, which it did.
What effect, if any, does Westlake's 2018 notice of termination of the QSA, which you referenced, which the department accepted, have on its breach of contract claim?
Sir, I'm sorry, I wear hearing aids and I didn't quite catch that.
Let me repeat the question. What effect, if any, does Westlake's 2018 notice of termination of the QSA, which the department accepted, have on its breach of contracts claim?
None. Because what that is that just as when the receiver takes its insurance, when the receiver takes over an insurance company pursuant to the liquidating order, all contracts at that point in time are terminated as of the date. All that did was say we are not obligated to any further obligation, but it doesn't extinguish any prior rights. There is no vacation of the agreement. There's no voiding of the agreement. It's just that we are not, Westlake Re was not required to continue forward in that case. So what happened in April, we got notice, Westlake Re got notice. We gave notice to the Department of Financial Services, and they declined to pay over the excess funds in the funds withheld account. That declination became a breach of the QSA. That declination on June 9, 2023 was an action that would allow for an arbitrator to decide whether or not that was a breach or it was authorized. That's the first time that we actually had, in April was the first time we had an admission from the department that there were excess funds available. And the first action that allow us to bring an action in front of an arbitrator, because we actually had worksheets from the department showing excess funds available, was on June 9, 2023. And the request for relief from stay and the request for arbitration followed immediately after that, within very short order. In this particular case, we then, that request for the lift for stay was denied by the circuit court. And as we've put forward in our brief, we made a proper demand for lifting the stay and an order compelling arbitration.
Counsel, do you need the stay lifted in order to engage in arbitration?
I believe you do, because I'm following the precedent that was established in Nova Insurance that was decided in 1992.
I mean under the statute.
Well, I will say, Judge Thomas, that was the subject of discussions that we had with the circuit court judge before, and she entered an order in January of 2022 where she indicated that we didn't have standing to challenge any disbursements at that time, even though we were challenging the disbursements, that they were non-assets of the estate, and that she had to have an evidentiary hearing with regard to whether there were non-assets of the estate. However, once the DFS issued its and modified its reports in April of 2023, that essentially declared that there were assets that were non-assets of the estate that would be subject.
Now, counsel, I do want to address something real quick before we get too far down the path. I have a question about our jurisdiction to address the trial court's ruling as to the statutory automatic stay. So reading her order, the order that we're reviewing, she separates the issues. She addresses the stay issue, which is the statutory automatic stay and whether she's going to lift it. She denies that. Then she moves on to addressing the arbitration issue and makes a ruling as to that. So under Rule 9.13, it appears we do have jurisdiction over the arbitration ruling because that is one of the expressly listed things in 9130. What is our basis for jurisdiction over the stay ruling that you raise here?
Well, I will tell, Your Honor, and if you want a particular rule or statute, I will defer in my rebuttal time to my colleague because in that regard. But I will say that because it is a one combined order with respect, and I know she differentiated the issue, I think that the court has the ability to determine the applicability of the statutes with regard to the stay because it is an abuse of discretion standard. And in this case, if there's an abuse of discretion, and when one doesn't properly follow the law, that is a per se abuse of discretion. And when the court looks at the reasoning that was provided by the circuit court, as we identified, she identifies approximately 3 different legal bases, but she doesn't properly refer to the law in this case. The first case, she indicates that there are only 2 instances by statute when you could lift the stay, when 63.1-021 just merely essentially says that if there are non-estate assets, then they are not subject to the stay. Now, what's ironic about this is if you look at 63.021 and non-estate assets are not subject to the stay, then there should be a mechanism where someone says you don't have to lift the stay.
Well, Counsel, going back to Judge Northby's question, you addressed the standard of review. Looking at paragraph 8 of the trial court's order, it says, for the above reasons, the motion to lift the stay is denied. Now, what is our basis for jurisdiction for your appeal of the denial of the motion to lift the stay?
I believe that was based on the fact that there are certain requirements for an interlocutory appeal that go to certain rights. And Judge Lewis, I will again ask Mr. Brown to address that in our rebuttal time, specifically on the procedural aspect in Florida in this case. What I do wish to say with respect to that, and that will be addressed, is ultimately we have to look at the issue with regard to arbitration, and we have to look at the argument that is made by the DFS that they are the only party that can decide whether one goes to can invoke the arbitration provision. And that just strains credulity with regard to the law, because there's nothing that suggests that the government stands in a superior position of any other party with regard to the processes that are available. I am into my rebuttal time, and I'd ask the court for leave to take advantage of that after the case, unless the court has any other question.
Thank you, counsel.
Thank you.
May it please the court. I'm Debbie Macon. I'm with Leidecker LLP, and we are here on behalf of the Department of Financial Services as the receiver for Guarantee Insurance Company, which I will refer to as GIC. Also with me here is Jamila Gooden. She is a senior attorney with DFS. What this appellate court is answering are two questions. One, whether the receivership court found that Westlake waived any right to
Judge,
arbitration
she should
it could
pull that
have.
microphone closer,
We can't hear you, counsel. Pull the
Okay.
microphone closer.
and she can lower them.
Should I lower this?
You can.
Okay. So, question one, whether the receivership court found that Westlake waived any right to arbitration it could have based on its 2.5 years of inconsistent litigation actions taken, which were apparent on the face of this record.
But their whole argument is that they didn't know until those work papers were delivered that they had this final number of 1.9 million. And I know in your brief you mentioned that number is actually not final and it fluctuates. Could you address that, please?
Absolutely. So it is the same, qualitatively, the same breach of contract they've had since the receivership estate began, okay? And it's really not true that the thing that we sent them in April 2023 was the first time they were able to quantify a number. There is a number they put in their notice of claim, which is 5.2, and that is based on GIC's accounting records. For all of our reinsurers, we have a team of accountants we've hired with exam resources. So we produce for them funds held reports at different intervals. And so Westlake has received different numbers at different times. And because we were going to have exam resources deposition being taken in April 2023, I asked her, I said, can you run the numbers one more time for year-end 2022 before your deposition? Because I'm sure he's going to ask you those questions. So the number does fluctuate, and eventually the numbers do contract because all of these claims are matriculating out. Some of them are becoming closed, so the numbers get, but in a sense, DFS, there isn't finality here because the notice of determination they received is a code 77, and it has a dollar amount, which is 00. And what that tells them is, well, one, there's also a class determination when they got it, and it was class 6. The 00 in the code 77 tells them we are not evaluating anybody in class 6. It's not just you, okay? And the reason the department tells them that is the department is charged with conserving the resources. And why would we ever pay for the accounting for all these junior classes when we have a $1 billion insolvency where we're probably not going to be able to leave class 1? So, to some extent, the reason we produce this is creditors, there is an exclusive statutory claims process here. And creditors are allowed under that to have their day in court. Perhaps the department may have gotten something wrong. They are allowed to test that. What we had been working for the last 2.5 years is a 631-182 hearing. And that's where they test that. And the January 2022 hearing, the order that was appealed in the prior appeal, one of the things that Judge Dempsey was able to say there is you have to complete the process. We have to know whether we got the right class, and we have to also adjudicate the property of the insurer. The part that answers this question is really, if you look at 631.021 sub 6. And it basically says that upon the liquidation order being entered, the Circuit Court of Leon County has exclusive jurisdiction over all assets or property of the insurer wherever it is located, even if it's out of state. There are other provisions in Chapter 631 as to exclusivity. And that's what we're talking about. We have an exclusive statutory procedure created by the Florida legislature to have a very organized and comprehensive way to deal with the aftermath of a failed insurance company, which has multiple shareholders. Westlake is not the only stakeholder here, I should say, not
So you have this
shareholder.
comprehensive statutory scheme. How does 631-206, the arbitration provision of that scheme, fit into this? It seems to acknowledge that arbitration is a part of this in some way. What way is it a part of this?
It does. And to go back to 631-0217, there's one other thing in the statute. It says that Chapter 631 constitutes Florida receiverships laws, and these laws, meaning every provision of these statutes, have to be construed as consistent with one another. That's sub 7, okay? So that is how we're going to have to examine 631-206. Where does it fall within the swath of all of these other things and all of these sentiments about exclusivity? For example,
I understand your argument in reference to the statute 631.206, but if we interpret section 631.206 to mean that it only applies to actions filed by the department, wouldn't we be improperly adding words to the statute that the legislature didn't include?
That is actually a secondary policy argument we briefed because they had brought it up. And there are different ways other states and other courts have done it, but there is a provision for arbitration that should be upheld. But in this case, what the lower court looked at is not any of these policy reasons, because we never got to that. We were hoping we could have one global issue, one global hearing that settled all of these intertwined issues, but we didn't get there because Westlake quickly rushed this along with a motion to rule and demanded the lower court rule on it.
But I understand Westlake argues that the trial court should have held an evidentiary hearing before ruling on its motion to lift the stay and to compel arbitration. Should the trial court have held an evidentiary hearing in the proceedings below?
Yes, and she did say, I can hold this on December 11th. I can adjudicate these issues. That's in paragraph 6, 7, and 8 of her order. But that's the thing. They want to split the baby here, and then they want to basically entice the lower court to rule, but without having provided her the proper proffer. If you go to what does it take to lift a stay, 631.041 sub 2 tells you, and it has something very specific here. There is an evidentiary burden of proof. You have to establish by clear and convincing evidence that the judgment that you're seeking is not voidable or void by the receiver, and the property from which the judgment would be satisfied does not constitute premium funds or another asset belonging to the insurer. That's a very high burden. And who has that burden? Westlake does. Knowing it has that burden, it then tells the lower court, go ahead, let's rush this along and you go ahead and rule. But what do they put into the evidence? Well, I'll tell you, they have one thing stapled to their motion to compel arbitration and lift stay. It's the quota share reinsurance agreement. It's not the, last accounting and the department saying, sorry, still claim. It's still subject to the exclusive statutory claims procedure.
Is it the department's position that it can never be compelled to arbitrate on an insolvent entity's behalf?
No, that isn't the department's position. We've supplied some of those out-of-state case laws to help this court see some of the policy areas of how arbitration flows with all of these other sections. A lot of other states have very similar versions of Chapter 631 because it's meant to work together in an interstate scheme. So we supplied that, but the ruling below is something that the court made based on the face of this record. It's kind of black letter law that there's 3 things under Seifert that you have to establish. Do you have a valid arbitrable issue? And ultimately, this gets back to the lower court, this receivership court, making a property determination as to what is an asset of the insurer. You cannot arbitrate that away. And why?
But counsel, if, as Westlake contends, GIC held a portion of its property, what was the appropriate way for it to recoup that property if it wasn't in a breach of contract action?
So there is the exclusive claims procedure, okay? That is how you have your 631-182 hearing, okay? And it is the same breach of contract claim they're really doing through the administrative process. But 631-271, which is also part of this, Florida's Insurers Rehabilitation and Liquidation Act, has a priority scheme. And there it has several different classes of creditors, and they're going to, first of all, have to show the classification is different to be able to say that this is some extraordinary breach of contract claim that doesn't fall within this exclusive statutory proceeding. That is a common law, general unsecured creditor claim. So there may be multiple instances where you could go to arbitration, but here, all of this is subject to the receivership court, which has the exclusive jurisdiction, this is 631-0216, to make the determination what is property of the insurance company. And upon that determination, that kind of solves everything else. In some instances, and I'm just going to give you a hypothetical, assume that this receivership, for whatever reason, was able to collect maybe, I don't know, $500 million, okay? It's probably not going to happen, but if it were, one of the things they would have to go back and do is they would have to go back and look at all of the creditors that they said, hey, look, we're not even going to look at you. We're not leaving class one. Now they are going to have to come up with some final numbers for all of these people. Those instances, there is the possibility if, let's say, Westlake didn't like, what is the final number? And that's what we don't have here. We don't have the department really adjudicating a final number. What we have is the latest accounting. They could possibly say, I would like to arbitrate this issue with you, okay? So it's not like we're saying, hey, this has to be invalidated. Arbitration has a value. There are many times where the statutory overlay that's in 631-206, as the department, we have said this is our most efficient route to do the things that we are required to do under the statute. But here what we have is a creditor who does not like being told it is class 6, it is unlikely to get anything.
They argue they're not a creditor in their brief.
So I understand they're saying that, but it is the same thing, whether they call them a creditor or a claimant. They are seeking assets of the insurance company. And they admit on page 2 of their brief that the quota share reinsurance agreement is based off of premiums paid by policyholders that are supposed to serve as the security for the underlying relationship. Just based on that admission alone, how could the lower court have been incorrect to say, you provided me nothing for clear and convincing, and yet you've asked me to rule on whether I should lift the stay? She ruled, no, you can't, not on this record. And all of these issues that are so intertwined with this, meaning, was your class determination correct? Is this property of the state? What are you seeking? All of these things, I'm going to make those determinations at an evidentiary hearing. This is one of the reasons we had asked Westlake, can you set one global hearing where all of these intertwined, interrelated issues can be adjudicated together? And they didn't want that. They wanted to rush ahead and force the earlier ruling. And we believe Westlake's counsel is extremely talented, Mr. Plotchin, Mr. Brown, and they know what the black letter law is. This 2.5-year wait, they know they waived it. They don't like where, after 10 depositions, which the lower court was aware of because she marked how much discovery had been taking place. She was the same judge who sat when Westlake sought affirmative relief before the court in trying to obstruct disbursement.
Counsel, was there any point before April 2023, that the department provided an accounting to Westlake of GIC's funds withheld?
Yes, in 2018. This 11th hour request for arbitration, coupled with the aggressive motion to rule, this is nothing more. The only logical interpretation is it is the fast tracking of an interrupting appellate distraction. So the lower court can't exercise jurisdiction on the one thing she does have exclusive jurisdiction over. It was to serve as the prospective cudgel to stay the December 2023 hearing. As much as they would like to tie this to, well, you told me I'm not going to get $1.9 million of excess collateral. That's not what a funds held report is. We give these to all of the reinsurers. This is something we have to track because at some point a reinsurer may be in a positive territory, But 2 years later, they end up in negative. At that point, I have to sue, well, when I say I mean the department has to sue them for a breach of contract action, okay? This funds held report is not, oh, we've got $1.9 million of your money. It's an accounting. It's a balance statement. It's not a statement of funds available.
And so
Okay.
you said that was provided to them in 2018. What, is that in the record, or what specific document, or in
I-
2018? Date, what date in 2018?
I know we did because we, at that point, we had exam resources kind of recalibrate everybody to see where are these numbers. They did come up in Susan Heath's deposition. So to the extent her deposition is a part of this particular appellate record, it's in there. And you had asked an earlier question about, do they have a cause of action into that? It is qualitatively the same cause of action. We all know all you need are some damages. You don't need some finality. And they never did really have finality, okay? Because the department itself hasn't adjudicated the number that it's going to give every Class 6 claimant. After inviting this court the lower court to rule, Westlake does not get to complain that it received an unfavorable ruling. And when the face of this record sustains neither the contractual right to arbitration, shows it was waived, and nor did they sustain their clear and convincing evidentiary burden of proof. With that, I'll close, if you don't have any other questions.
Thank you, counsel.
Okay.
May it please the court. Judge Lewis, I'd like to address the question you asked opposing counsel first, because you asked if prior to 2023, was there any report? She said yes, there was, but that's not a complete answer. There was a report, but there were no excess funds because the reserves that were identified by DFS exceeded the amount of cash that was in the account. Because the importance of this is the first time that we were able to do anything under the contract is under Section 7, I believe, E, when the excess funds are in excess of the formula as to which includes claims paid and reserves. So for her to make a claim that in 2018 we had an ability to bring in a claim for arbitration is not true. And I'm not aware of anything in the record, to answer Judge Norby's question, that would suggest that there's anything, that there was a report from DFS that we had the ability to seek an arbitration.
What about your opposing counsel's argument that you're just another Class 6 creditor and you can just wait in line with all the other creditors, and there's probably not going to be any money left anyway, because it's $1 billion sunk fund, so to speak. In your brief, you say you're not a creditor.
So actually, Judge Thomas, I had highlighted when you asked that question, because I have the liquidating order. And the liquidating order says that they can take possession of funds of the insurer. If they are not funds of the insurer and they are Westlake's collateral for debts they may owe the insurer, it's Westlake's funds. And therefore, even though they marshaled it, I started this day and I said they marshaled assets of the estate and non-assets of the estate. So not only are we not a creditor, but the funds in our withheld account are not assets of the estate. They happen to be in their control at this point in time, and that's why we're asking for return of possession. It would be the equivalent of...
Well, on what basis are they calling you a creditor?
I don't know. I don't know why they're calling us a creditor. I think actually there was a deposition in which they said, well, we just kind of assigned this tag to everyone who was a claimant. We're not even a claimant under the administrative process.
Well, I don't want to eat up all your rebuttal time, but, you know, in your initial brief, you talk extensively about how the department failed to respond to your motions, violated the procedural rules of the circuit court, never responded, would not set a hearing, and, you know, it painted a fairly ugly picture of where you were. So now you have a ruling on arbitration, and so what are you going to do if we rule in your favor?
Well, I
You
think...
actually asked, you had two request in your relief, so to speak, in your initial brief, either rule as a matter of law you're entitled to arbitration, I assume, or remand. What would the remand look like?
Well, remand would be for the evidentiary hearing that we tried to set when it was just ruled that there was not going to be a lift stay and so
But your
forth.
opposing counsel just said, we wanted a global evidentiary hearing anyway, and you jumped the gun.
Well,
How do you respond to that?
Well, because under the rules established by Judge Dempsey in the court, when we filed our motion, they had 10 days to respond, and if they didn't respond, it was to be deemed as defaulted, unopposed. So when we went and we
Well, that
didn't
was
ask for...
discretionary. It reads may be deemed uncontested.
Yes, that's
So
true, but
at
the relief
discretion
we
of the
asked
trial
for,
judge.
Judge Norby, was we said we would like you to either find it unopposed or give us an evidentiary hearing so we could have because we didn't want to go through the time and expense of a hearing on what I believe are collateral administrative process issues when we're really talking about
Yeah,
a
and I
breach of
think that's what I'm
contract.
trying to ask you about. May I impose more time, Judge? Thank you.
Okay.
Chief, you lawyers are far more steeped in this process than I am. You know, I have your briefs on the record. So clarify for me, okay, if we order a remand and we don't address the stay, Judge Nordby has asked the question whether we even have jurisdiction. We'll have to decide that over the stay. Assume we're not going to affect the stay, but we rule in your favor on arbitration, or we remand for a hearing on arbitration. Tell me what that's going to look like in terms of this administrative proceeding that they keep hammering on in their brief, that, oh, you have to wait for the administrative proceeding. I assume, I'm sorry for this long-winded question, but I assume the administrative proceeding is their way of saying you're just another creditor.
That is correct, and we're saying there's not really, the administrative proceeding was, all it was scheduled for was for us to address our objections to their dispersing funds until the court made a determination as to whether there were non-assets of the estate, non-assets
So
or
when
assets.
When will the court make that determination as to non-assets?
The court doesn't have to make it if the court finds in favor of us in arbitration, because that divests the court of it, and that's something for the arbitrator, which Rule 631-206 contemplates that arbitrators are going to make decisions with regard to this in terms of the
So
contracts
is the
that are presented.
arbitrator going to look at the
Yes.
estate assets and non-assets?
Yes, because
How is that different than the administrative proceeding?
because it's the contract right that we have, and there's a public policy precedent in favor of arbitration. And secondly, the administrative proceeding is in the context of what rights does someone have as a claimant in the administrative process. We are a third-party entity. We are not a claimant, and therefore we are not subject to standing in line with everybody else and priority and so forth, and that law and regulation shouldn't govern that. With regard to and if I may, because Judge Norby asked and I promised I'd get back to you, I spoke, Ms. Brown, it is our position that there is not a distinction between the jurisdiction for arbitration and the jurisdiction to lift stay, because they're part and parcel of the same motion, because the court can't order arbitration unless it lifts the stay. And it's not, oh, first I make a lift stay, fine, I don't do it, and then I consider arbitration, because the basis for lifting it is to support the arbitration. So if you have jurisdiction for the arbitration, then you have, the lift stay comes with it. And the reason, if you think about it this way, Judge, is that if that's not the case, then no circuit court judge ever has to compel or move anything to arbitration, because they can say, oh, I'm wrong on the arbitration, but there's no jurisdiction for the appellate court to consider a lift stay, and I'll just deny the lift stay. And there's no way for that ever to be reviewed, and there's no way to enforce the ability to have someone arbitrate what they have contractually agreed to and they're entitled to in that case. So with all respect to the judge who wrote it separately, I don't think jurisdictionally they're unique and distinctive. I think when she wrote it, it was trying to look at certain laws as to whether or not there was exclusive jurisdiction and so forth, and I don't believe that that's the case. In this case,
There were two rulings by the trial court. The first ruling was to deny your motion to stay, and the second ruling was denying your request for for arbitration.
I agree, Judge Lewis, but they're part and parcel of the same motion.
Let's assume for the sake of argument regarding your arbitration claim
Yes, sir.
that you lose on that. That is, let's assume for the sake of argument that there was a waiver. What effect would that have on the motion to deny the state, if any?
I would think that if the court rules that there was not a denial of the right to arbitrate, then I think that ends the issue. Okay, at that point. I don't think that there's a separate appellate issue associated with the lift state for the court's jurisdictional purposes, but there is a separate intellectual analysis as we apply the statute, because the reason the court granted or made its reasoning with regard to whether or not it was going to lift the stay or not, it said first we have to have a judgment, but the statute doesn't say you have to have a judgment. It says you have to be able to obtain a judgment, and then the whole question of whether assets are going to be the assets of the estate will be impacted. Well, that's going to be what the arbitrator is going to decide, because it's our position all along they're not assets of the estate. If the arbitrator says, I'm sorry, Westlake Re, these are assets of the estate, then we lose an arbitration. And that's where it is. But that's not that's how I think it proceeds.
Your position is they're not assets of the state and that you are not accredited. Is that correct?
That's correct.
And these were your funds, right?
Yes, sir.
Okay. Were these funds commingled by GIC with other funds?
They were. Not by yet, and they were.
Do you lose the nature of the funds since they were commingled with other funds?
In the absence of a contractual provision stating otherwise, I would agree with that proposition. However, specifically under the QSA, under Section 7, subparagraph F, it says that the parties that GIC may commingle funds as long as it separately maintains the accounting so as it can distinguish what funds are in the same account. The analogy would be just like a lawyer's trust account. I have one account, but I am able to segregate and know whose funds are applicable with regard to that, and someone has the right to their funds as accounted for in a trust account. And by contract, under Section 7 of the QSA, that's the only authority to commingle the funds. If there wasn't a contract and GIC had done that as a tort, that throws us into another area that I don't know the answer for, and I don't know that is contemplated by the court. But in this particular case, there's a contract that authorizes the commingling as long as GIC could separately segregate and identify the funds, and the DFS, standing in the shoes of GIC, has separately identified those funds and told us what they are, and has said that at this point, once we reduce the risks, and to properly reflect claims that we've actually paid, there's $1.967 million that are excess funds based on, regardless of what the highest assumption of risk that you could have. And that's why there are funds and we're entitled to them, and we should allow an arbitrator to decide that. It's an important case for my client. I know I'm over my time. I thank you all for your attention and for reading the briefs. Reading briefs on insurance law may not be the most exciting thing, but we value it, and we'd ask the court to consider the merits of our case accordingly. Thank you.
And thank you both counsels for your respective oral arguments this afternoon. This concludes our oral argument for this afternoon. We stand adjourned.
All rise.
Good argument. Thank you. You were intimately involved. Good argument.
Thank you.
I don't know if you two are intimately involved as well, but if you are, good argument. Okay.
Yeah, great job.
Thank you.